who spoke about the tooth that was found at the property. It'd be one thing if this evidence had already been presented, then the court could have looked at this and thought, maybe the juror didn't hear it. Maybe the juror heard it and thought, this is not sufficient. Here, this evidence had not been presented yet. So we have this juror who's latched on to this comment that was made in an opening statement and declared to other jurors that he has a hope that this evidence will be presented.
But the term hope, can't it be interpreted in two different ways? So hope in the sense, it sounds like you're interpreting it, that they are reflecting some type of expectation and desire for the people to prove that from a positive standpoint from the people's perspective. But can't it also be interpreted as a hope, as a sign of some perceived weakness in what's been presented so far?
Again, given the context, no, I don't think so, because the prosecution did then later call a DNA expert and called the forensic anthropologist who talked about the tooth. Given Juror 6's declaration to the several other jurors that were around him, and there may very well have been more that we don't know about because of the trial court's failure to inquire.
How is that inconsistent, the later presentation of that evidence, with a reflection that the juror had some doubt about the completeness of the prosecution's case at that time?
Because he's expressing a hope that it will be presented, and once it is presented, he's going to be a lot less likely to back off from that position. Harmon recognizes this, Flockhart recognizes this. This is the danger with pre-deliberation conduct. You have a juror conveying his position on the evidence to other jurors while the prosecution is still presenting its case. So no matter how weak or how equivocal that later evidence might be, it's going to be much less likely that that juror is willing, just due to human nature, to back off of that position.
You had mentioned the presumption of innocence. There was a presumption of innocence instruction given at the close of the case and also at the beginning?
Yes, Your Honor. And same is true in Harmon, Your Honor. Here, after the court met with the three jurors, the response that the jury received was for the court to say, "Thank you for your continued hard work and patience." This is how this is the impression that these jurors were left with when this was resolved.
I have a question about the standard of reversal here. Let's say we agree with you on one hand, but that we conclude that any objections weren't preserved because, as Judge Dunn pointed out, defense counsel didn't really suggest to the court that it take any additional corrective action. Should we be reviewing this for structural error, plain error? How would this work, assuming that we agree with you that the court should have done more?
Your Honor, I think you could apply structural error. I acknowledge that Flockhart applies a constitutional harmless error. If you're reviewing for plain error, this is substantial prejudice that Mr. Frazee has suffered for a number of reasons. First, when Harmon goes through the harm analysis, all of those factors are present here. This comes before the final instructions and argument. It comes late in the prosecution's case. This isn't an instance where we have a juror expressing a vague concern at the beginning of the case when the prosecution hasn't presented any of its substantive evidence of guilt. All of these points weigh in favor of reversal. This also goes to the critical issue in this case, which is whether there is physical evidence to corroborate Ms. Lee's testimony and her statements and her allegations toward Mr. Frazee. This was the contested issue in this case. Much of the physical evidence did not support Ms. Lee's testimony and her allegations. There was no video evidence of her coming and going to the condo. Her DNA was not found in the condo. So this goes to a critical point in the case. It happened at a critical time in the case, and the trial court failed to fashion a remedy that addressed the specific misconduct. As to the next issue, the trial court permitted extensive testimony by Mr. Priest about Ms. Lee's credibility. There's just no other way to look at him testifying while a video of Ms. Lee's statements and allegations is played and paused while he comments on the consistency of those allegations with the physical evidence that he saw and the physical evidence that she described. This is plainly erroneous under Venalonzo and Eppins and Witrine, and it should have jumped off of the, it should have jumped to the court's attention as it happened, because there's just simply no other reason for him to be going through this back and forth. The prosecution essentially had two witnesses up on the stand testifying. You had Ms. Lee with her, with her statements in the video, and then you had Mr. Priest who was commenting on them. This is plainly erroneous under, like I said, Venalonzo, Witrine, and Eppins. Eppins recognizes that consistency is a gauge of credibility. So this is why the division in People v. West is incorrect when it states that the detective said nothing about the truth of the testimony.
Was the trial here before or after Venalonzo?
It was after Venalonzo.
Okay.
Venalonzo was a 2017 opinion, and the trial here was in 2019. So it's plainly erroneous under long-settled Colorado Supreme Court precedent. Venalonzo, Eppins, Witrine, and West is inconsistent with that. Were this an area of the law where the trial court was dealing with an issue that the Court of Appeals had addressed and only the Court of Appeals had addressed, like we see in the state's cases that it relies on, it'd be one thing. But here we have West, which is clearly contrary to Eppins, Witrine, and Venalonzo. So in this circumstance, the court has to look to the controlling Supreme Court precedent, and a division of this court isn't free to carve out an exception to that precedent. Beaubien doesn't hold otherwise. Beaubien was addressing an issue of prosecutorial misconduct. The opinion repeatedly explains or notes that as presented to us, this doesn't reach the flagrant, glaring, tremendously improper standard that this court has to apply with plain error prosecutorial misconduct. Here we're dealing with an evidentiary issue. Again, this is reversible because it goes to the critical point in the state's case, which is Lee's credibility. None of the other evidence corroborated Lee's description of the condo. In fact, like I had mentioned before, much of the evidence was at odds with that description. If the court doesn't have any questions, I'll reserve the remaining time for rebuttal.
Good afternoon. May it please the court. My name is Brittany Zahner, registration number 48733, and I represent the people. I'd like to start by pointing out that overwhelming evidence showed that the defendant solicited Crystal Lee 3 separate times to kill his fiancée and the mother of his child, that he bludgeoned her to death on Thanksgiving Day in 2018, and that he and Lee went through an elaborate plan to clean the crime scene, burn Barrett's body, and incriminating evidence, and lay false trails suggesting that Barrett abandoned her daughter and her family and disappeared of her own accord. So while the defendant claims that several errors occurred during his over 2-week-long trial, the record shows that few, if any, errors actually occurred, and any that did were harmless, given the overwhelming evidence. To start with the juror misconduct issue, the court acted well within its discretion, and it certainly did not plainly err by not sua sponte admonishing the 3 jurors who talked about the case or polling the rest of the jury to ask about pre-deliberation instructions. Following Harmon, the court didn't sit silent and do nothing. It called the jurors out individually to ask them about this conversation. And after it assessed their credibility and the responses to its questions, it concluded that they could be fair and impartial. And without any requests from defense counsel for further admonition, for further questions, or a request to further examine other jurors, the court's decision here was not manifestly arbitrary, unreasonable, or unfair. I also disagree with the defendant's characterizations of the jurors' conversations here. I think it's far from clear that they were, these discussions involved pre-deliberating. I would point out that Juror 4 testified that the conversation was about the anticipation about the balance of the case. Juror 9 talked about that the main conversation was about the court's mention that the trial was going to, closing arguments were going to happen on that Friday, wondering about the balance of the presentation of evidence, thinking the prosecution must be close to finishing its case, and wondering what the rest of the evidence would be. This is not an indication that that these 3 jurors had already predetermined the defendant's guilt.
What about, Mr. Lacefield is, I think the strongest argument here is the word hope, and the hope that the prosecution's case would come together. Can you explain why that's not pre-deliberation, in your view?
I would say that the juror's statement about hoping that things would come together isn't necessarily an indication that this juror believed that any future evidence would prove the prosecution's case beyond a reasonable doubt. I think it reflected the fact that during opening statement, the prosecution had mentioned that the victim's blood and DNA showed the victim's blood in her apartment. The CBI serologist testimony talked about the samples that she tested did test positive for blood, but she didn't test DNA, and other analysts did that. I think that it was reasonable for the juror to just be thinking about, what is this DNA evidence going to show? How are we going to kind of close the loop on that? What is this evidence actually going to be? I don't think, or at least certainly a reasonable person could interpret this juror's comment to just be wondering about what evidence was going to come next, and not necessarily that he believed it would prove the defendant guilty.
I think Mr. Lacefield also is saying the inquiry wasn't adequate because it didn't address presumption of innocence. And it's true, from what I can tell on the record, that particular phrase was not reviewed with the jurors. So is that something we should be concerned about here?
I don't think so, Your Honor, because nothing in the jurors' conversation indicated that they couldn't apply or they weren't applying the presumption of innocence. I think that the record, particularly the jurors' statements about kind of the context of they're just wondering what witnesses are going to come next, how is the testimony going to wrap up, and sort of the logistical nature of what was going on. None of the jurors said that this would impact their ability to be fair and impartial. I believe Juror 4 said that there was no discussion about the merits of witness testimony or the credibility of witnesses. And so without some further indication that these jurors weren't affording the defendant the presumption of innocence, I don't think there was any plain error for the court not expressly asking about that. And Judge Grove, I think you asked about the standard of reversal. It's the people's position that any error has to be plain to merit reversal in this case, particularly because the defendant, though given numerous opportunities to make records about the court's admonitions or to question these jurors themselves, repeatedly declined to do so. And I think that if it was preserved, structural error is not appropriate. Flockhart makes clear that any pre-deliberation issues are subject to a constitutional harmless error analysis. And particularly given the overwhelming evidence of guilt in this case, any error was certainly harmless beyond a reasonable doubt. Although the victim's body was never found, the defendant confessed in extensive detail to Crystal Lee and solicited her help to burn the victim's body and to cover up evidence. And her testimony was corroborated by substantial evidence. Dozens of witnesses testified about things like the cell location data, which corroborated Ms. Lee's testimony about their movements, particularly with the victim's cell phone movement, moving with the defendant's phone and then going with Ms. Lee to Idaho. There was a bloodhound that alerted to the smell of human decomposition in the location that Ms. Lee testified they retrieved the tote containing the victim's body. Ms. Lee pointed out the location of the burn site, where there was melted black plastic consistent with the black tote that the defendant carried her body in. as well as an oily substance that was either consistent with motor oil, which Ms. Lee testified was used to burn the body, with human body oil from a burned corpse, or both, as well as a human tooth fragment, that there was no other explanation for why that tooth fragment should be there.
Ms. Zehner, can I ask you, I know, Mr. Leesfield, we didn't get into the evidentiary errors, but you both analyzed them under 404B. Does People versus Rojas change your analysis on any of that evidence?
It does, thank you for asking that, Your Honor. I think it only does slightly, but not in any way that changes the outcome. So for the unpreserved errors, I would argue that any error was not plain, given that at the time of the trial, the res gestae doctrine would have allowed pretty much all of this evidence to come in. So for those unpreserved errors, any error was not obvious because Rojas was decided
Was any of that,
after.
I'm sorry to interrupt, was any of the evidence that we're talking about admitted as res gestae, or was it all 404B?
I mean, with the evidence that wasn't objected to, it's not clear how it was admitted. There was some discussion at the motions hearing before trial about whether the prosecution was going to file a 404B notice. The prosecution expressed its intent to introduce what it characterized as res gestae, evidence regarding background between the defendant and the victim, and the defendant and Ms. Lee. And so I think that the kind of baseline understanding was that evidence that provided context for their relationship was res gestae, unless there was a specific 404B instruction.
Can I ask you to switch gears again? So jumping to an issue that wasn't addressed by the defense, the issue of the felony murder count in this case. It seems that the people's theory of the case was that there was sort of a coincidence of, or a commission of both a robbery, the taking of the phone, and a homicide, and that constitutes felony murder, that the murder occurs at the same time or contemporaneous with a robbery. But the statute seems to contemplate that there is a primary offense that is intended, and that incident to that primary offense, in this case it would be robbery, that there's a homicide. So the statutory language is in the course of or in furtherance of the crime, referring to, in your theory of the case, the robbery, the people's theory of the case. But it seems like the evidence is pretty clear that the robbery is sort of an effort to cover up the homicide. At least I think that's factually what was the people's theory of the case. So in that circumstance, does the felony murder statute apply, and if so, why?
Yes, it does, Your Honor. So I think you might be referring to the defendant's argument that there had to be some kind of intent to commit the robbery and that the person had to die in the course of that robbery. But I think the plain language of the statute doesn't support any kind of temporal or timing requirement, and particularly when the underlying predicate is robbery, where as long as there is a taking at any time during a course of transaction where a defendant uses force, the defendant can use force first and then effect the taking. The defendant can take and then use force. As long as the force occurs in the course of a transaction that culminates in the taking of something from the person or presence of the person robbed, that is enough.
The question I have is more, what's the primary intent? In this case, the primary intent wasn't to commit a robbery. Would you agree with that? Or do you believe that the primary intent was to commit a robbery and the murder was incidental to the robbery? Or that the primary intent was to commit the murder and the robbery was incidental? Or does it matter in your mind?
I don't think it matters, Your Honor. I don't think there's anything in the statute that says the defendant has to primarily intend to commit the underlying predicate and someone just has to happen to die during the course of the felony. I think that if a person goes in with the intent to commit a murder and does so and then also commits a predicate felony, that would support both after deliberation murder and felony murder. And I think a division of this court recently recognized that in Vasquez, which is 2022 COA 100, that kind of talks about the felony murder statute and how really it applies whenever a defendant commits a predicate felony, and in the course of that felony or immediately afterwards, a person dies as a result. So I think that is sufficient to satisfy the felony murder statute.
I know we've jumped around, Ms. Zahner, but can you also address Mr. Lacefield's arguments on the improper blood spatter expert's testimony and whether you think that's bolstering testimony, and if not, why?
Yes, Your Honor. So I disagree that it's bolstering testimony for a couple of reasons. Corroborating testimony is not bolstering, and particularly in this situation where a witness is talking about physical evidence and scientific evidence that he observed. This wasn't a situation where he was listening to the testimony of a witness or someone else and essentially evaluates their credibility based on the kind of credibility factors we normally think about. Was their testimony consistent with prior statements that they made? I think when the cases for bolstering talk about consistency, they're typically talking about cases where one statement is consistent with another prior statement, and that this suggests that the witness's testimony is more reliable or more truthful. But simply having evidence or having testimony that says, I observed this physical evidence and it is consistent with, a theory of the case where the defendant bludgeoned the victim with a bat, I don't think rises to the level of bolstering. But if this court...
That's different. You said consistent with the theory of the case, but Mr. Lacefield's argument is it's consistent with what she told the police and what she testified to. And so I think that's slightly different. And so if you could focus on, it would help if you could focus on why his statement that it's consistent is an error or plain error.
Sure. So I think kind of for the reasons I discussed, the fact that the witness is testifying that the physical evidence corroborates someone else's statement is not necessarily a statement that he's saying, I listened to her testimony and found it credible. That would be bolstering. Saying, I listened to her statements and the physical evidence is consistent with that is corroborating. And it's not necessarily offering an opinion on her credibility. But if this court disagrees, any error was certainly not plain, either at the time of trial or at the time of appeal, particularly given the fact that divisions of this court have reached opposite conclusions about whether testimony similar to this is bolstering or not. And the defendant relies on Venalonzo to suggest that this error was plain. Venalonzo is a very different case. Venalonzo involved an expert who was testifying about interacting with victims, the kinds of things that victims might say. And I can't remember if Venalonzo was a child abuse case or a sex assault case. But I think that that's vastly different than the situation we have here, where a blood spatter expert is testifying that physical evidence corroborates a person's statements, rather than giving the jury a set of factors that they could consider to assess the victim's credibility. So my time is up. The people would ask this court to affirm. Thank you.
Thank you, Ms. Zahner. Mr. Lacefield, you have about just under 4 minutes left.
Your Honor, as to the first issue, this is not overwhelming evidence of guilt. It's far from it. Nothing in the evidence that the prosecution presented here aligns with the type of evidence that Colorado courts have recognized provide overwhelming evidence of guilt. We don't have a recorded confession. We don't have indisputable physical evidence that's found in someone's possession, such as what we had in, I believe it was Flockhart or Procario Flores. This simply is not overwhelming evidence of guilt. There's contrary interpretations on much of the evidence. There's exculpatory interpretations on others, and much of it relies on Crystal Lee's credibility, which was hotly contested, and there's much reason to doubt. This is someone who admitted giving multiple false statements to police before being offered an extremely favorable plea agreement, and then all of a sudden changing her story. This is far, far from overwhelming evidence of guilt. Harmon does not stand for the proposition that doing something is enough, which is what the state seems to suggest, that because the trial court did something, then that ends the inquiry. Harmon doesn't just say, so long as you do something, then there's no error. Harmon lays out a number of different steps that the trial court could have taken, and as I mentioned, they are all specifically tailored to the specific misconduct that it was presented with, which is failing to presume the defendant innocent. We can't presume that jurors 6, juror 4, juror 9 all of a sudden started complying with instructions that they had failed to comply with before. This is not a situation where the trial court gave an instruction explicitly allowing pre-deliberation conduct, telling them that they could discuss the case. This is the opposite. The trial court repeatedly instructed them that they were not to discuss this case, and their discussions were so alarming that juror 5 stepped away from the group, exclaimed loud enough that the court staff could hear him, "I'm not going to be around this. I'm not going to sit here while they continue to talk about this case." That's what brought this to the court's attention. They thought they were being fair by, in the middle or in the late part of the prosecution's case, expressing a desire the prosecution would present scientific evidence of guilt. They thought they were being fair. They weren't. They weren't affording Mr. Frazee one of his most fundamental rights that's guaranteed to all of us, Your Honor. As to the second issue, Your Honor, this is not an instance where we have a blind expert who is talking generally about blood spatter evidence and how that might be created. Mr. Priest talked extensively about what Ms. Lee had told the investigators at the scene, as, like I said, her video was played for the jurors to watch. As to the court's questions about the prior bad act evidence, anything that was not specifically analyzed under 404B is likely, presumably, admitted as some sort of res geste. To the extent that this is plain error, it was plainly against Mr. Frazee at trial. It is now plainly in his favor, as divisions of this court have recognized. This is sufficient for error to be plain when it becomes plain at the time of appeal. And under Rojas, that is now settled. Your Honor, for these reasons, I would ask that the court reverse Mr. Frazee's judgment of conviction. Thank you.
Thank you. I want to thank both counsel for your excellent arguments. They will be very helpful for us in deciding the case. A written opinion will issue in due course.